Hello, welcome to completing the petition for AOT, Guidance for Emergency Departments. My name is Scott Smith, and I'm a technical consultant with the Center for Behavioral Health and Justice. Today's training is going to be specifically targeted to emergency department personnel, to the social workers, and other personnel who frequently handle petitioning process more broadly. I also want to qualify that as an employee at a very large hospital, I understand that completing petitions is very routine. I also appreciate that staff turnover, the need to hire additional staff, has been a chronic problem for some time now. And it is our hope that this training will be something that you can utilize during your onboarding process to take some of the burden off of your existing staff and their training needs. So I'm going to cover the petitioning process a little more generally at first, and provide a more contextualized application to assisted outpatient treatment where appropriate. This is Form PCM 201, Petition for Mental Health Treatment. For those of you who have been working in emergency departments or other areas of mental health care, you're no stranger to this form. For those of you newer to this form, it is updated regularly as there are legislative changes to the mental health law. So be sure that you're always checking the SCAO website to ensure you're using the most current version, as older versions expire in terms of their acceptability to the courts. This training is being filmed in early 2023, and we're using the most current version. Keep that in mind if you're accessing this webinar later and there's been any changes to the mental health law. As always, if you have questions about this training, please submit them on the frequently asked questions section of this website. Now, diving into the petition, one of the things we always want to be mindful of is that we are in many ways translating our clinical interpretation and experience with a patient to the legal world. So it's important to understand what this form is asking for and why. So on that initial line in the matter of, this is where we're going to put the individual that we're petitioning, the subject of the petition. We're going to put their name here. We're going to use their legal name. And this is especially important if somebody has not changed their name but is choosing to go by a different name. We still need to use their legal name because this is going to be attached potentially to their state ID, especially in cases where somebody is subjected to involuntary hospitalization. This is the information that will potentially be entered into the National Criminal Instant Check system to prevent somebody who should not, for example, be able to purchase a firearm from purchasing a firearm. So that's why it's asking for some very specific information. In situations where you don't know the person's name, potentially they come in as a John or Jane Doe, you can put John or Jane Doe in this line. Part of what this form is going to seek to do is also make sure that people are not confused because they share the same name or ethnicity. So please take your time to make sure that you're including the appropriate legal information here. You don't have to worry about the court ORI. That will be provided by the court. And new to this particular version are the clear instructions to not include the social security number, date of birth, and now you see a driver's license request. On Form MC97, also available on SCAO's website if you don't have it within your hospital intranet, is the cover sheet that is now attached to most legal forms to ensure the protection of somebody's privacy. So the next box you're going to need to fill out is place of birth. It has been generally regarded that you can just use the state. You can obviously be as specific as you want, but the state is sufficient. Country is important if the individual was born outside of the US. Again, this aids in identification. Under the box for race, census categories seem to be preferred. And those general categories include American Indian, Alaska Native, Asian, Black or African American, Native Hawaiian, or other Pacific Islander, and white. And under the box labeled sex, this is going to be asking for legal sex. So if in legal documents in the state, individual sex is listed differently than the way the person identifies, you still need to use that information that's aligned with the other documentations. This is one area of law that may change soon, so please stay tuned to the court websites to see if there are any changes. One final point before I move off of this slide. For those patients we're interacting with in the ED who identify as trans, non-binary, because they have a legal right to their medical record, to this documentation at some point, I personally have found it helpful to give them a heads up that, I'm completing a form that legally requires me to put legal information in it. And this is why I'm doing that. And when you look at this form someday, I want you to understand that that was the purpose, the rationale for me doing this. We know that individuals who identify as part of the LGBT community are disproportionately at risk for suicidal behaviors. And I think anything we can do to encourage them to feel safe and welcomed in our healthcare settings is vitally important because of the numerous health inequalities they experience as a result of their gender identity or their sexual orientation. And when we get to line 1, obviously you're going to be the petitioner. Or if you're helping a family member or friend of the patient, it would be their name. And their relationship is simply how they know the person. For hospital employees, it might be registered nurse, might be social worker. You're going to put this in, and keep in mind that when this is reviewed by a court, oftentimes when they see nurse, social worker, psychologist as the person completing the petition, it actually adds a different weight to the validity of the contents. For better or for worse, that is a potential influence that the completing petitioner has. Down on line 2, obviously they're requesting that date of birth again, which is found on the face sheet, for lack of a better term, form MC97. And it's going to ask for their permanent residence, their county of permanent residence. This is for several reasons. One, to establish which court has jurisdiction. And secondly, to establish which community mental health provider would technically have, overview of this case. This must match their legal residence. If they are homeless, you can use the county where they're located, the county of your facility where you're completing this form. And on that next line for their street address, again, what is their legal address? And if they're homeless or have some other type of unstable housing, writing homeless is usually considered completely sufficient and can presently be found at, and that's essentially where you're completing the petition. This line is especially helpful for individuals who are in the community, not in a controlled environment like an emergency department, but you will merely put your hospital's facility name and address in this location. One thing that's often a time saver for hospitals is to download the original form from Scale. And because it's now a fillable PDF, you could enter in some of this information, such as facility name or address, and then photocopy and distribute those versions. Or if you complete them electronically, create a master PDF record with some of the set information filled out, just to improve the overall efficiency and expedience of this end of paperwork. There's a box under line 2 that reads, "This petition is for a person who is found not guilty by reason of insanity in this county," a condition known as NGRI. It's unlikely in the emergency department that you will have knowledge of this. So most of the time, you're not going to have to worry about checking this box at all. One other note to add. In the event that you're completing this paperwork for a patient who eloped, it would be helpful to include under that line, can parents presently be found at, where you last knew them to reside or spend most of their time. Because if police are executing a transport order, it'll be very helpful for them to find the individual in a timely fashion. Line 3 is where we get into the actual rationale for being able to petition somebody for either involuntary hospitalization, assisted outpatient treatment, or a combination of the two. So with mental health law in Michigan, we always start from the premise that the individual is experiencing a mental illness, is living with a mental illness. That is a person requiring treatment, as it's often presented in the state law. So this is not a person who primarily has a substance use disorder. This is not a person who primarily has dementia or has epilepsy, some other condition. And there's a reminder, because of the fact that this is a civil legal process, this is why it's so important that we're completing this form on individuals who are not legally intoxicated, specifically with alcohol. So their blood alcohol level needs to be under 0.08 or 80 nanograms a deciliter. If they are not at the time of completing this form, and those records are ever reconciled, and by the way, this applies to the physician certification as well. If they are not legally sober, any of the information used in these forms will be considered invalid by the court, and it will be promptly dismissed. So this is why we always want to make sure that we're checking on that blood alcohol level, and that our date and time on our both cert and on our petition align with the sobriety of the patient. There are 3 boxes that you can check. And yes, you can check all 3 of them or any combination therein. I'm going to go box by box and talk about reasons where you can actually check the appropriate box. And I'm going to add here that there have been many changes to the mental health law. And for those of us who have been in the field for a longer period of time, a lot of these changes went unnoticed or with very little publication. But for example, with box A, historically, the person had to be an immediate threat, had to be, an immediate danger to themselves or others. But the mental health law now reads that as a result of their mental illness, the individual can reasonably be expected within the near future to intentionally or unintentionally seriously physically injure self or others, and has engaged in acts making significant threats that support this expectation. This is a change. So it's no longer required that we wait until an individual gets to that true suicidal and or homicidal state. We can intervene earlier. By adding language such as reasonably be expected, it allows us to draw on any prior knowledge we have about the patient, for example, their patterns of decompensation. It also allows us to exercise our clinical judgment to say, this individual, for example, is experiencing psychotic symptoms and specifically paranoia. They may unintentionally injure themselves by fleeing a threat that does not actually exist. I've had patients who have run away from an imagined threat, a hallucination, or more particularly a delusion. They were feeling as though somebody was specifically out to get them, so they ran across a busy road to try to escape, and ended up getting hit by a car. That would be sufficient reason to check box A. So again, this is a change, especially for those of us who've been in the field longer, and it's a reminder that we don't have to play the dangerous game of waiting until somebody is on the brink of danger to self or others before we intervene. And as a reminder, anytime legally we see terminology implying reasonable, what we're talking about is, would somebody else similar to you, similar training and experience, come to the same conclusion. That's the standard that we're going to be judged against. So check this box, obviously, if there's the overt threats of hurting themselves or others. You can also check this box if they confirm that they made a threat. And I'll touch on that again later. But this is going to apply specifically to other legal procedures and rules of evidence. And again, as a reminder, if they're experiencing psychotic symptoms, right, which most commonly we think of hearing voices or delusions like paranoia. But remember, this can include disorganized thinking. It can include any of the negative symptoms of psychosis. And it's important that we recognize that, because by definition, somebody experiencing psychotic symptoms, they're unpredictable, because we cannot anticipate how, in their altered experience of reality, they are going to respond. Box B is referring to an individual's ability to meet their activities of daily living. So if they're not eating, bathing, keeping their home sanitary, if they're not taking medications necessary to sustain and preserve their health. For example, they have diabetes type 2 and they're not compliant with their insulin. If it's because of their mental illness, specifically, remember, we're talking about as a result of their mental illness, right? If they're not taking their medication because of their mental illness, they're not eating, bathing, keeping their home sanitary because of their mental illness, not getting out of bed to go to work, take care of the kids, go to school, then we can check this box. And we're very fortunate in Michigan to have this provision. In many states, this is not an option. And regrettably, too many individuals who could otherwise be helped don't receive the help they need because they're not presenting with that clear, overt, suicidal, homicidal statement. And finally, box C. And box C is especially important for assisted outpatient treatment. This is the box that refers to an individual's impairment in judgment because of their mental illness, and specifically how their lack of understanding that they need treatment is likely to inhibit their ability to adhere to any treatment, and is very likely, as a result, to cause a deterioration of their condition and or result in danger to themselves or others. Now, this area of the law was specifically changed several years ago, and it's one area that I consistently see people who have been in the field for a while completely missing that this has changed. It used to read more specifically that this failure to understand that they need treatment has resulted in a certain number of hospitalizations or incarcerations over the last 48 months. But as the mental health law was changed, we no longer have that same burden. So to check this box, what we're looking for are those individuals who either don't recognize that they're ill at all, a condition many people refer to as anosognosia, something we see in stroke patients, dementia patients. There's debate, obviously, within the mental health world that this is what that condition truly is, but it resembles it insofar as they don't recognize at all that they have an illness. This would also apply to those individuals who their symptoms interfere with adherence to treatment. So in their paranoia, they believe the medications are poison. They believe that the treatment providers are actually trying to kidnap them or hurt them. This can also apply to individuals who like the way they're feeling. And for many people who are in a manic episode, they don't consider that condition to be distressing. And as a result, treatment adherence tends to be very low or non-existent. So check this box if, because of their mental illness, their judgment has impaired their ability to understand that they're sick, that they need treatment, and we can see that they're unwilling to voluntarily participate or adhere to treatment. And what's important to consider here too is that if we have prior knowledge of, let's say, how they decompensate, either through our records in the EMR or through collateral sources of information, we can check this box. And this box is what is going to ultimately qualify somebody for assisted outpatient treatment. The great thing about being able to check this box and use it as a basis for assisted outpatient treatment is that it gives us more room to intervene, a wider window. So if we know that somebody often follows a predictable pattern of not adhering to their psychotropic medications, decompensating, and as they decompensate, experiencing suicidal ideations, command auditory hallucinations telling them to hurt somebody else, we don't have to wait for that to happen. We can intervene now. So that's a great reason that we can check that box. Now, they don't have to meet currently criteria A or B if they have a history of meeting criteria A or B. So remember, just because you can't check box A or B does not mean you can't check box C. Number 4 is, for lack of a better term, the affidavit portion of this document, right? Where we're attesting to the reason we have the belief that this person needs treatment. The conclusions stated above are based on option A, my personal observations of the person doing the following acts and saying the following things. And then we've got box B, the following conduct and statements that others have seen or heard and have told me about. So the law does not specifically prevent you from using hearsay, that is, secondhand information, to complete this petition. However, if this petition goes before a judge, secondhand information will fall under the rules of evidence and the hearsay rule specifically, so it would be disallowed. So it's a best practice to make sure that we can complete this by using personal observations. If we can't do that, if we only have secondhand information, in those situations, it's typically better to help the person who has firsthand knowledge complete this petition and be the petitioner. Now, one helpful tip, if, for example, we see somebody in the emergency department who is reported to have sent text messages or made a statement that they wanted to kill themselves or they were going to kill themselves. If we approach that patient and ask, did you send a text? Did you say to your mother, to your friend, you were going to kill yourself? Not surprisingly, many people will not be honest about that. Instead, if you approach it from an assumption of the premise being true, that is, this is true, and instead ask the person why they said that, why they sent that message. Oftentimes, as people, we're inclined to want to explain our behavior as opposed to necessarily deny in the same way we would if we were asked a yes or no question. So instead of asking, did you send a text message saying you wanted to kill yourself? You could say something like, so I heard you send a text message saying you wanted to kill yourself. And I'm so sorry that life has gotten so bad that you're feeling that way. Can you tell me a little bit about what's been going on that left you feeling like you wanted to kill yourself? And often they will explain or help you understand what they were feeling. And by confirming that they sent that message, you now have firsthand knowledge. So there's no longer an issue around hearsay. So that's a little pro tip that hopefully can be helpful in ensuring that your efforts to get somebody care doesn't get disregarded because of the rules of evidence. Now, there's nothing wrong with adding additional information from collateral sources in box B, but it's not necessary. If you can fill out information under subline A of number 4, that is sufficient. And remember, This is obviously going to be seen by many other clinicians throughout the process, but this is primarily a legal document. So it's best, when possible, to avoid as much jargon and confusing language as possible. Be very straightforward to the point. The individual endorses suicidal ideation with a plan to hang themselves, and they have access to the means to carry out their suicidal plan, period. You don't have to write an extensive narrative here. If a judge is uncertain about what is going on, they'll give you a chance to testify. Ideally, we've got things to do, so we'd like to avoid that. So the more clear, concise, and succinct you are here, the greater the likelihood you won't necessarily have to appear to explain what you were seeing the day you completed the petition. When we get to the back of the form, the first line there, number 5, these are the individuals interested in the proceedings. And this is helpful to provide for several reasons. One, because the court may be interested legally in some of the decision-making realities, or might be considering limiting decision-making through a guardianship type process. So obviously, if the person has a guardian, if you have that information, it definitely expedites things. This is also helpful if you're sending the person out to a different receiving facility for inpatient psychiatric care. It's helpful for them to have some of this collateral information located here on the form. Line 6, if you know their veteran status, by all means, please check this box. If you do not know, if you're unsure, leave it blank. Number 7, because you're in an emergency department, you typically are going to have access to a clinical cert. Now that cert is, in most emergency departments, going to be completed by a physician, not necessarily a psychiatrist, as sadly we have all too few psychiatrists in this state. We're not alone. Very few states are swimming in psychiatrists. Other than some of the most desirable areas of the country, psychiatrists remain in very short supply. If you have the cert from the attending physician, you're just going to check box number 7 and that first line. I'm going to talk real briefly at the end of this webinar about ensuring alignment with that clinical cert, so make sure you stay tuned for that. You do not need a clinical cert, however, if you're only requesting assisted outpatient treatment. So in a situation where you do not think this individual requires immediate inpatient hospitalization for safety and stabilization, but you see this patient several times a month. This person has really gotten comfortable in your emergency department, one of our familiar faces. Many of these individuals are unknown to community mental health because they either rarely end up being hospitalized, they just come into the emergency department. Often after a night's sleep and some food, their symptoms seem to improve dramatically. But nevertheless, you know that they're living with a mental illness, you know that they're not seeking outpatient treatment, and they continue to decline. This is precisely for whom assisted outpatient treatment is designed. So you don't have to have any clinical certificate if you are requesting assisted outpatient treatment from the court. So that's an important distinction. You don't have to burden the attending with anything. Another important point with box number 7. If you don't have a clinical cert, either because you didn't need it because you're only requesting assisted outpatient treatment, so you're checking box 7, and the third box, no clinical cert, is attached because only AOT is requested, or in a situation potentially where the patient eloped before they were examined, then you're going to not check box 7 in a situation where there is no cert, but you don't know what the person will need because they weren't evaluated, and you will check the next box, box 8. For the cert to be properly filled out, box 7 or box 8 need to be checked, not both, and certainly you should not leave both of those blank. Under box 8, this is where if you're requesting hospitalization or combined treatment, that is assisted outpatient and hospitalization, but you don't have a cert. So for an emergency department, the person eloped, and you're going to want that person basically to be brought back for an examination, either to your ED or in an ideal world, a facility better suited to making this determination, a drop-in center, a CCBHC crisis center, for example. What you're going to want to do is check box 8 and just explain why an examination could not be secured. The patient eloped. The patient was discharged, and later we received additional information from collateral sources. Sometimes, as you know, we get somebody brought to the ER, nobody is present with them, and we make a decision based on the information we had. Later on, somebody comes in and they're like, oh, I forgot to leave the suicide note. That happened to me once. So now I was in a situation where things changed. I would have made a very different decision had I had this information previously. As a result, needed to get law enforcement involved to go and actually pick the patient up. So we're going to check box 8, a brief explanation for why we couldn't examine the patient or get the examination completed. Also, if you're guiding family members, whether they're calling on the phone or it's a situation where for some reason you're helping them and the patient isn't around, or preparing them maybe for a future where this might happen. There are a lot of reasons why the exam couldn't happen. It's usually because the person doesn't want to do it. And simply writing the patient refused is sufficient. But if it's a situation where maybe they've been in jail for the weekend, they're about to get out, and you know that their mental health has played a role in that, so you want an evaluation, an examination, that's where you would, indicate that here. And the second half of box 8 is what your specific request is. So box A is the individual be examined at, and every county or CMH, area is going to have preferred locations. You can always specify the emergency department. It's just not ideal, as those of us who work in the emergency department know. In a perfect world, we would see far fewer individuals with mental health crisis in the emergency department, simply because we're not set up to handle mental health crises in the way that other places are. I'm very optimistic that the new funding and expansion of clinically certified behavioral health centers, CCBHCs, will help relieve some of that huge burden that's been placed on emergency departments over the last several decades to be the end-all be-all for people with mental health crises. So it's important that if you're filling this out at the hospital for somebody who needs an evaluation, if possible, actually request that they be examined at that appropriate pre-screening unit with the CMH, especially because they are going to be better set up to actually make the evaluation of whether assisted outpatient treatment, for example, is appropriate. And as the gatekeepers, they're also the ones that are authorizing the inpatient stays, as we know. So having them go to their center is obviously ideal. And typically, you're going to want to check box B, because regrettably, if the individual is eloping, if they're refusing to come in, they're probably not going to be sweet talked to doing this. I think it's always appropriate to make the attempt, and I want to be clear about that. We should make every attempt to try to persuade or encourage somebody to go in, not only because the more we avoid their contact with law enforcement, the safer everybody is, but also because the more somebody actually buys into their own treatment, participates in their own treatment, the more likely they are to actually experience benefit from treatment. We know that those two things are inextricably linked. So we want to make every attempt to do that. But when that's not a possibility, a judge can actually issue an order for transportation and examination, and that will be precipitated by your completion or a family member's completion of this petition. And by making sure that box 8 and 8B are checked, that will be necessary to get that order for examination and treatment. Box 9, this is where historically, most of the time as an emergency department staff member, you were completing this for people who you were going to send to an inpatient psychiatric setting. Historically, you were only ever checking, one box for hospitalization. Now that we have a more accessible assisted outpatient treatment law, you have other options. So which box you check under number 9 is really important. For individuals for whom you really only think they need currently to be stabilized, then hospitalization only is the most appropriate response. This is somebody you don't have any prior history with. You don't necessarily have enough information to conclude that they have a serious mental illness, that you might not even have enough information to make a diagnosis outside of that category of other, right? So with the revisions to the DSM, starting with DSM-5, we lost the old school NOS, not otherwise specified, and replaced that with other depressive, other bipolar and related, other schizophrenia and related. If you don't have enough information because it's an emergency department and you just got a brief snapshot, it's going to be pretty hard to necessarily make an argument that they would be eligible or good candidates for assisted outpatient treatment. However, as an emergency department, you see patients, we all see patients over and over and over again. We call them a number of things, high utilizers. The current term we're trying to use to be more sensitive and less derogatory is familiar faces. You'll note that that has the same initials as frequent flyer, which was previously and maybe still a very widely used term. We're trying to use familiar faces because we want to be sensitive to the fact that it is, in fact, their illness that results in them seeking out care in the emergency department. Now, obviously, there are behavioral components to that as well, and we're very mindful of that. These are things that we discuss in the full webinar on assisted outpatient treatment that you can find on the website. With number 9, for those individuals that are familiar faces, and currently you feel, yes, they're not stable enough to be discharged back to the community, they need to be hospitalized, but we see them all the time. They're not following up with treatment. Box B would be the appropriate box to check. You want both hospitalization now, and you would like further evaluation for assisted outpatient treatment so that hopefully the individual is now getting outpatient treatment instead of relying on the emergency department for their services. The one newer option, the one thing that most EDs are not currently doing, is considering the role they can play in identifying individuals who simply may be good candidates for assisted outpatient treatment, but not hospitalization. Obviously, in the emergency department, our primary concern is, does this person meet the criteria for a higher level of care, the medical necessity criteria or not? If they don't, then we typically discharge to outpatient treatment. But for individuals we see over and over and over and over again that we know rely on the emergency department, and very frequently inpatient hospitalization in a psychiatric facility for their mental health care. Any of these individuals, especially if they're not getting hospitalized very often, are simply not on anybody's radar within the community mental health system. This is especially true of those individuals who are living with a serious mental illness, and as a result of that serious mental illness, have been considered legally disabled. So they receive SSDI and Medicare. Because they have Medicare primary, they don't belong to the CMH. That's not CMH's charter. So those individuals often go completely unnoticed by the CMH until they've used up their lifetime psych days and their Medicare Part A days because of frequent hospitalizations. And now their secondary Medicaid has to kick in to be the payer for their inpatient hospitalization. This is an enormous problem, as many of the highest utilizers of emergency department services actually are those individuals with Medicare. For hospitals, another very important consideration here, those same individuals, because they have Medicare, are often responsible for the multiple readmissions within 30 days that were penalized for under the Affordable Care Act. So there are multiple financial motivations for hospitals to consider modifying procedures to complete petitions for individuals who would benefit from assisted outpatient treatment. This is going to be new for virtually everybody. But for those familiar faces, checking box 9C, completing the petition, I should say, in the first place, and checking box 9C, and filing this with the courts, which is going to be the newest procedure, the procedure you're going to have to, implement in most cases, in most EDs. By doing that, you actually have the potential to help the individual leave a more full and healthy life, to reduce ER visits, ER caseload volume, to reduce unreimbursed care, to reduce avoidable days for those times they end up medically admitted, to avoid the penalties for multiple readmissions within 30 days because they have Medicare. For all of these reasons, which again are explained in more depth in the full webinar, assisted outpatient treatment for that individual could be an enormous asset for your emergency department to engage in. Finally, with box 10, for those individuals that you, under number 9, checked either A or B, if you believe they need hospitalization, you're going to also need to check box 10 because you don't want to wait 3, 5, 7 days for a hearing. You want them immediately to be hospitalized, start receiving care, start being kept safe prior to that hearing time. Now, if you're checking box 9A, if you're checking box 10, A or B under item 3 should also be checked. If under item number 3, you did not check box C, you should not be checking 9B or 9C. So remember, for assisted outpatient treatment, you are definitely going to want 9B or C selected, but it needs to match on the front of the form under item 3 and have at least box C checked. And finally, on the form, you're just going to agree that this, as an affidavit, falls under the pains and penalties of perjury. So the facts contained therein are true to the best of your knowledge. Date it, sign it, provide the address and phone numbers. For those of you who might be newer to the emergency department, it's important that you use your work address and work telephone number, not your home information. This document, under the rules of evidence, will be available to the individual. Additionally, This document will also be filed with the court potentially and would be publicly available. So somebody could literally access your county's court records, look at this document and be like, oh, my favorite nurse, my favorite social worker lives at this address. This is their home number. And I think we can all agree that having good boundaries is important in our respective fields. So we're going to want to make sure that we're only giving our work information out. Now, as a final thought, in those cases where we are going to have a cert, a physician cert, that is PCM 208, that's accompanying our petition, it's always a good idea for us to do the double check and make sure that the physician cert and our petition align. So I always recommend that we make sure that under line 6, an appropriate diagnosis is included. Very often physicians will, write suicidal as a diagnosis. And we want to helpfully maybe direct them to consider, well, are they suicidal because of depression, because of a prior diagnosis? Use an appropriate diagnosis. I've also found sometimes, and especially with newer residents, that they will include as a diagnosis something that's excluded. Primary diagnosis is, alcohol abuse. Okay, well, that's not going to qualify. So make sure you're checking there and making sure that they're coming up with an appropriate diagnosis. Very often, by the way, the emergency attending, the emergency resident will appreciate this additional help, because this is, not always a part of their normal preparation and training. And we're also going to want to make sure that over in box 10, if we're requesting assisted outpatient treatment, that the cert and the petition both are checking the same box, either the combined box or only the assisted outpatient treatment. Now, again, I don't think there's any need necessarily to have the physician in the ER, or if you have a psychologist in the ER who completes your certificates, I don't think there's any reason to have them fill out a cert if you're only requesting assisted outpatient treatment, because what you're going to want is an evaluation at an appropriate facility, typically a CMH facility, in order to get that determination made. So just make sure that if you're requesting a combined order, so you have naturally a cert, make sure they don't check hospitalization only if you want to also have assisted outpatient treatment considered. I want to thank you for your time, and be sure to keep checking back on our website for further updates and helpful information. And again, submit your questions under our frequently asked questions section, and we'll do our best to be responsive and be part of helping you help the community. This training is presented as a part of the Michigan Assisted Outpatient Treatment Toolkit. And to learn more, please visit behaviorhealthjustice.wayne.edu/AOT.